Please tell me your name.
Name's Kenneth James Purvis.
2020 CF 11084. You're here because a capias was issued for your arrest for failing to appear for a status hearing on a charge of possession of a controlled substance and possession of drug paraphernalia. There is no bond authorized, and I'll appoint the Public Defender's Office to represent you. Good luck, sir.
Ma'am?
Yes, sir.
May I say something, please?
Yes,
I went
let me,
to the
but wait,
court.
before you say anything, let me advise you that everything you say is being recorded and can be used against you later. You
Okay.
understand that?
Ma'am, may I say something, please? I went
Yes.
to the original court date that they gave me over there in the Orange County Courthouse, and I have a witness, my manager, over there on 1736. I live on Mercy Drive, and I came back and told her that they had told me that there was no information and that it had been dismissed, and since then, she has also gave me another year lease there. Also, we have been working with the Spire Center next door, and I was supposed to go back this week with getting my medications, and ma'am, also last week we had reapplied for my food stamps, and ma'am, on Sunday I went to Celebration because I had pains right here and got a bunch of prescriptions. I went out panhandling. Knoxville County Sheriff had arrested me, and they said I was wanted in Orange County for that, and I said no. They told me that was dropped. I've called my manager, young lady, I still have 7 months paid for there, and a house full of stuff and very clean, and reported to her on Friday that we were working on it. The only thing I test positive for was marijuana and a Valium that the Osceola County Sheriff had gave me because it was about my last day of drinking. But ma'am, this was a total lack of communications, and I swear for you to God, I have been working on it. They can tell you I ain't tested positive for cocaine or no heroines, but ma'am, I went there and they told me that stuff was dropped.
I
have
believe
literally
you.
been working on it.
Listen, sir, I believe what you're telling me. Unfortunately, because this was a capias signed by another judge, I can't change it. But what I'm going to do is ask the public defender if you can make notes about what he has said, because if he wasn't supposed to be in court, or if he did show up and there's a way you can file a motion to get that capias dismissed or quashed, the judge will likely do that.
Yes, Your Honor, no
All right, so the public defender's office is going to work on that right away for you.
Okay, well, ma'am, then what's my next court date?
So I don't have a court date for you, but what can happen is your attorney can file a motion very quickly and get you back in front of that trial judge. That's the only judge who can change this capias. I cannot.
And young lady, I'm not lying. I went back and told my manager.
I believe
she
you.
Gave me another year. If I mess up or look stupid, I'm going to lose my apartment and everything up in it. And I've been over there right now for 12 plus 5, 17 months.
Listen, sir, I believe what you're telling me. I do. But unfortunately, I can't change that capias because it was assigned by another judge. So I've asked the public defender's office to get a motion filed for you right away. On that green piece of paper is a phone number. You need to call that number as soon as you can. And then they can pull this record from this court hearing today and file a motion for you.
And ma'am, they got me in the bottom of the jail down here, and I mean, the room ain't even clean. Oh, and also I went and got all them prescriptions, and the officers gave it to some other lady that was on the street next to me. And I've been telling them I need them prescriptions while I went to that hospital on Sunday. But right now, they got me in a dungeon down there. The room ain't even damn clean. And I mean, it's just unbelievable.
I'm sorry, sir.
Unbelievable.
What you need to do is talk to your attorney.
I'm not BSing you, sir.
No, I believe you. I'm sure he does as well. I do believe you.
How long out do you think I am? Am I going to lose my apartment and everything?
I don't know the answer to that, sir.
I don't know.
But call the public defender's office right away.
Thank you, sir. Do you need my manager's number?
problem.
Please, take this. Take my manager's number, 407. This is for real. Michelle Cordona, she just got married. 407-747-5090. And she'll tell you, he went to the courthouse because when I came back and I told him, I'm a little slow. Maybe I should have got all these paperwork that said this and that and that and this. And all my stimulus checks and other things have been mailed to the Mercy Drive. So I seen on one of these pieces of papers, they were still mailing stuff to 144 Court. My own family ain't even lived there in 2 years.
Make sure that when you call that phone number at the public defender's office, make sure you tell them what your correct address is, because that's another thing. If the notice was sent to the wrong address, that's something that your attorney can use to ask the judge to quash the capias. But I can't.
Yeah, call the number and I'm emailing today.
Did you get her name, Michelle?
Yes, I did.
And she's the best, she's the
gonna-
best in the world, 5747, 5090. She says,
Okay.
Kenny, and we're working on getting, I'm a permanent. She thinks I'm a real great guy, and I am.
I believe you, sir.
We will.
So, you gonna?
They'll start working on your behalf.
Possible?
I will try, yes.
All right, good luck, sir.
Thank you. Thank you, Your Honor.
Yes, sir.
Sir, I need you bad, help me.
Sir, please tell me your name.
Keith, what?
21 MO 52380. You're here charged with open container of an alcoholic beverage. There is probable cause. Did the state have an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold on credit time served.
Was the public defender able to discuss that with Mr. Watkins?
No, it was not, Your Honor.
All right, do you want to take a minute right now? Mr. Watkins, did you hear what the state's offer was?
Your Honor, I'll let you keep going. If we can pull him onto the side, and then I'll speak to him,
Okay, can we do that, Dexter?
and you can go to the next.
She wants to have a moment to speak with him, and then we'll bring him back up.
Your Honor, can I
Yes.
just have 1 minute to organize my desk before,
To do what?
organize my desk,
Oh, sure.
please? Thank you.
Mr. Garrett?
Who is it? Good afternoon, Counselor. If you'd like to call your case.
Yes, good afternoon, Your Honor. Chelsea Simmons for Mr. Garrell. It's Donald Garrell, Garrell.
This is 21 CF 4802. A warrant was issued for your arrest, sir, charging you with lewd or lascivious conduct, lewd or lascivious molestation, and possession of a childlike sex doll. Another judge has already found probable cause in this case. Counselor, did you wish to be heard on, well, let me ask the state first. Yes, Ms. May?
Yes, Your Honor, as to count two is a live offense. State is asking for no bond pending an Arthur hearing.
All right. Thank you. Did you wish to be heard on any of the other bonds, Counselor?
Yes, Your Honor, we would object to the court denying bond today without holding an Arthur hearing. We believe that there is not proof evident presumption great in as to count 2.
So do you want to have an Arthur hearing?
Yes, Your Honor.
All right. Ms. May? Can you be prepared to do an Arthur hearing at the end of the docket?
Yes, Your Honor, the state's just going to ask you to look at the four corners of the affidavit.
All right. All right, so that's what we'll do then. We'll just move this to the end of the docket and have the hearing today.
Yes, Your Honor, thank you.
Where do I want to, you want to, okay.
I can stand right here, it's fine. Yes, oh yes, I'm fine. Good afternoon, Judge.
Good afternoon, Counselor. How are you today?
I'm well, thank you. How are you?
Good.
My name is Danielle Barbado, and I'm here on behalf of Mr. Gabriel Valentin Rodriguez in 21 CF, 12 CF 14101.
I was thinking, my head has a 12. Is mine wrong or hers?
I have the new law case in my head that I wanted to have an opportunity to explain, and if we had a moment to request bond in this violation of probation hearing.
All right.
Or the IA.
All right, so sir, you're here because a warrant was issued for your arrest for violating your probation by committing the criminal offense of failing to update your information as a sexual offender on March 22nd, 2021. So, Counselor, you may proceed.
Thank you, Judge. So in the new law violation, which is 21 CF 3353, no charging decision has been made at this time. That is a situation in which Mr. Valentin Rodriguez has been accused of failing to register at the DMV. However, the facts would lend themselves to establish that he did, in fact, the same day or within the 48-hour reporting period, report to and update his address with the sheriff's office. Now, the reason that he was unable to comply with the DMV is because there are no walk-in appointments available during the limited restrictions given the COVID. So he made an appointment. The first available was a week or a week and a half out, I believe. So he missed the reporting time frame that's statutorily required. However, communicated with his probation officer, registered with the sheriff's office. And in this situation, we do believe that we'll be discussing, hopefully, a dismissal from the state or a no information very early on in that new law violation. In the meantime, though, we'd like to have the opportunity to get Mr. Valentin Rodriguez out of custody so he doesn't lose his job and so that he can provide those text messages and emails that show receipts of appointment confirmations for the DMV. So we'd be asking that you set bond in a low amount today, $2,500.
All right, what says the state?
Your Honor, as this is a VOP, he's not entitled to bond, so state would be objecting. There is a new law. However, even though it hasn't been filed, he's not entitled to bond on a VOP. So state would ask that you maintain the no bond status.
And if I don't mean to speak while you're reading, Judge.
It's okay, I can listen while I read.
Mr. Valentin Rodriguez actually retained us in advance of the new law violation in an effort to make sure he was complying with all registration requirements in a change of address. And if you go through the 2012 case, you should see several motions and orders from Judge Blackman, or before Judge Blackman, and then orders from Judge Blackman regarding his residential address change. So Mr. Valentin Rodriguez has been wildly diligent in trying to maintain communication and be above board with all of the registration requirements. This is a situation in which he's not a flight risk. He does not pose a danger to the community. He maintains contact with his probation officer and his attorney. And in this situation, we do anticipate having his assistance out of custody to be able to expedite finding those appointments and those email confirmations to provide to the state in the new law case.
All right, Counselor, I understand your arguments. I'll tell you where the court is, and then you tell me what you think after that.
Yes, Judge.
He is not entitled to bond. I'm not typically inclined to grant bond for a violation of probation. However, hearing all of your arguments, it does sound as though he has made significant efforts to comply, and he's been on probation for 8 years? 8 of the 10, is that correct? The 10-year probation period?
Yes, Your Honor. There have been a few, I believe, a prior violation of probation on this case as well.
I can't hear you.
There's been a previous violation of probation on this case before as well.
I don't have that on my criminal history. When was that?
I have a violation of probation that was signed by Judge Adams in January of 2020. That was set for hearing April of 2020. They then had another hearing regarding his change of address in March of 2021, and then they just filed another violation of probation in April of 2021.
So he wasn't convicted?
Yes, Your Honor, he was.
Oh, he was?
No, I don't mean to.
Yeah, go ahead.
That may have been the situation in which he attempted to move to Seminole County and was given conflicting advice, got permission from Judge Blackman in a written order whose jurisdiction doesn't reach into Seminole County. Once he moved into Seminole County, he was then immediately told to move back and violated for that move. So the clarifying order from Judge Blackman came forth. Now, our concern is certainly obtaining that evidence as quickly as possible to exonerate Mr. Valentin Rodriguez, but also that we don't want him to lose his job. And it is a Thursday afternoon, so even if I filed a bond motion today in front of Judge Blackman, he would potentially be missing 4 to 5 days of work just to get onto the docket.
Your Honor, I believe I misspoke. The violation of probation that was signed by Judge Adams in January of 2020 was dismissed by the court.
It was?
Yes,
Okay.
Your Honor.
All right, so then Counselor, here's my other concern. I understand what you're telling me about they don't have walk-in appointments at the DMV because of COVID. But that's not a new situation. That's been our reality for a year and a half. So he knew that he needed to do that by a certain date. And it's been DMV's practice for 18 months now that they don't take walk-in appointments. So your client should have known that.
And I think the issue was that the DMV requires, the statutory requirement for a change of address is different than the biannual check-in required of a sex offender. So going in person to physically change his address was a different procedure than when he had been maintaining the same address. And he was unaware that an appointment was required for the walk-in.
Okay, here's what I'm going to do. I'm going to take a brief recess. I'll be back in 5 minutes so that I can look something up. Sorry, I don't want to keep everyone sitting here waiting.
Absolutely.
Don't let me forget about this one, too. All right, we are back on the record. Is this Mr. Watkins?
Yeah.
All right. 21 MO 52380, open container of an alcoholic beverage. Ms. George?
Yes, Your Honor, I did have a chance to speak with Mr. Watkins. He would like to accept the state's offer of a withhold of adjudication credit time served. I went over all the rights he would be giving up. He understands those rights, and he would like to accept the state's offer here today.
Raise your right hand, please, sir.
No contest.
I'm gonna go raise your-
Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yeah.
Did you say yes?
Mhm.
All right, sir. So Ms. George explained to you all the rights that you're giving up by entering this plea. Do you understand those rights?
Yeah.
Do you have any questions for me?
Hmm?
Do you have any questions for me
No.
about the rights you're giving up?
Mm-hmm.
And you understand that if you're on probation, this plea could violate that?
Yeah, I understand.
You understand that if you're not a U.S. citizen, this plea could deport you?
Yeah.
All right. Sir, at this time, how do you wish to plead to the charge of open container of an alcoholic beverage?
No contest.
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs, sir. I'm going to give you a year to pay them, okay? That's the longest I can give you.
Yeah.
All right. Good luck, sir. You have 30 days to appeal in writing.
I don't think she appointed us. I don't think we'll.
Please tell me your name.
Noah Burnell.
Thank you. You're here in 21 CF 5260AO, charged with traveling to meet a minor, unlawful use of a two-way communication device, and obscene communication. I'm going to appoint the Public Defender's Office to represent you.
Your Honor, we just asked for a low reasonable bond. There's no criminal history for our client. He's employed full-time for the last 4 years at the same location, so consider that in your discretion.
Thank you. There is probable cause in this case. I'll stay your bonds at $2,500 on count one, $150 on counts 2 and 3. You're not allowed to have any contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
You're also not allowed to use any dating sites, social media dating sites. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name. A warrant was issued for your arrest in 21 MM 3014 for tampering with a victim. Another judge has already found probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond is $5,000. You're not allowed to have any contact with the victim. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the victim's residence or be within 500 feet of the victim's residence, vehicle, or place of employment. Do you understand?
Yes, Your Honor.
In 21 CF 5172AO, a warrant was issued for your arrest for burglary of an occupied dwelling and robbery. Another judge has already found probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond is $10,000 on count 1 and $5,000 on count 2. Yes, sir?
Your Honor, that was my own residence.
So it was a warrant that was issued by another judge?
Both of those counts of burglary were my own residence.
So not according to the affidavit. According to the affidavit for the warrant for your arrest, you don't live there. So if you think that you have a defense to this, you're going to have to raise that with the Public Defender's Office, who I'm appointing to represent you in this case as well.
Yes, ma'am.
Again, you're not allowed to have any contact with the victim, possess a weapon or a firearm. You can't come within 500 feet of the victim's residence, place of work, or vehicle. You understand that?
Yes, ma'am.
In 21 CF 4981, another warrant was issued for your arrest for burglary of a dwelling, grand theft from a dwelling, dealing in stolen property, and providing false verification to a secondhand dealer. Again, another judge has already found probable cause. Your bond is $15,000 on count 1, $1,000 on counts 2, 3, and 4. You're not allowed to have any contact with the co-defendant or witnesses or victims. You're not allowed to return to the scene, and you're not allowed to possess a weapon of any kind, firearm, or ammunition. I will also appoint the public defender's office to represent you. Do you understand?
Yes, Your Honor.
In 21, oh no, that's it. All right, good luck, sir. Please tell me your name.
Jermaine Reese,
21 CF 523180. You're here charged with burglary of an occupied dwelling and resisting an officer without violence. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. I'm going to stay your bond at $5,000 on count 1 and $500 on count 2. You're not allowed to return to this scene for any reason. Do you understand? You have to answer out loud.
say yes.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to have any contact with the victim in this case. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. And after him, I'm ready to hear Mr. Valentin Rodriguez again. All right, sir, please tell me your name.
Robert Jolly.
21 CF 5264. You're here charged with obscene communication, traveling to meet for obscene purposes. At this time, I'll appoint the public defender's office to represent you. There is probable cause. Your bond will be $2,500. You're not allowed to have any contact with any minor child under the age of 18. Do you understand? You're also not allowed to use any internet, social media, dating websites. Do you understand that?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
Good luck. I don't know why it does that sometimes. All right, this is 12 CF 14101 AO, Mr. Valentine Rodriguez. So, Counselor, I told you I'm not usually inclined to set bond in these kinds of cases. In this case, I'm going to set a bond, though your client is not entitled to one.
Thank you, Your Honor.
But I don't think I can set it as low as $2,500. I'm going to set the bond at $5,000.
Understood.
Sir, you still have to maintain all of your sex offender reporting requirements. You understand that? I can't hear you.
Yes, ma'am.
All right, so you need to make sure that you keep in touch with your attorney, which you seem to be, because if this happens again, I don't know what Judge Bleckman's going to say the next time.
Okay.
All right?
Any other conditions or requirements, Your Honor?
Any other conditions the state would request?
No, Your Honor.
Just whatever other conditions, his probation conditions he needs to still maintain. Good luck, sir. Thank you, Counselor, and thank you for your patience.
Thank you very much, Your Honor. Have a good day.
You as well.
Thank you guys very much.
Please tell me your name.
Jeremy Jones.
A warrant was issued for your arrest in 21 CF 5111, charging you with lewd and lascivious molestation, lewd and lascivious conduct, and contributing to the delinquency of a minor. Another judge has already found probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Does the state wish to be heard on bond?
Your Honor, given that none of these are life or PBL offenses, he is entitled to bond. State would just ask for a reasonable bond, given the nature of the offenses, that they are sexual in nature, and taking into account the multiple accounts in the affidavit, or in the warrant, and the age of the victim, which I believe was 15.
At this time, your bond on count 1 will be $25,000. Your bond on count 2 will be $15,000. Your bond on count 3 will be $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You may not send a message through friends or family members, no contact at all. You also may not have any contact with any minor child under the age of 18. Do you understand?
Yes, Your Honor.
You also may not possess or consume any controlled substance without a valid prescription.
Yes, Your Honor.
I'll order that you have to comply with any plan set in place by DCF. Were you living in the same house as this victim?
No, Your Honor.
All right, then I'll order that you're not allowed to return to that residence or be within 500 feet of the victim's residence. You understand?
Yes, Your Honor.
Any other conditions the state would request?
No contact with the victim's family.
I will order that. You're not allowed to have any contact with the victim's family. You understand?
Yes, Your Honor.
Good luck, sir. Please tell me your name.
My name is Pedro Suarez, Your Honor.
21 CF 526980. You're here charged with attempted lewd or lascivious battery and obscene communication. I'm going to appoint the Public Defender's Office to represent you. Yes, Counselor, did you wish to be heard?
Your Honor, we just ask for a low reasonable bond. Our client's employed full-time for 10 years at the same location, no previous criminal history in Florida or in other states. And I would appreciate you considering that in your determination.
Thank you, Counselor. It's what?
I think it's coming from Pleas area.
I don't know why it's doing that. All right, let's try this again. Your bond will be $5,000 on count 1 and $150 on count 2. You're not allowed to have any contact with any minor child under the age of 18. Do you understand that? I'm sorry, I couldn't hear you.
I understand.
You're also not allowed to use any social media or internet dating sites. Do you understand?
I understand.
Good luck, sir. Please tell me your name.
Nathan Woods.
21 CF 525180. You're here charged with aggravated assault with a weapon. There is probable cause for your arrest, and I'll appoint the Public Defender's Office to represent you. Your bond is $2,500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Were you living in this residence?
Yes, ma'am, I was.
All right, you can't now. I'll order that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that through the victim. You understand?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
Thank you.
Please tell me your name.
Natasha Stewart.
20 CF 11385. A warrant was issued for your arrest for violating your probation by failing to report to the probation officer as directed. There is no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Good luck, ma'am.
Spanish interpret cases, Your Honor.
Thank you.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you. If you could please connect to the headset. Sir, please tell me your name.
Sí. Ronaldo Agüero Jiménez. Ronaldo Agüero Jiménez.
Ronaldo Agüero Jimenez.
This is case 21 CF 525580. You're here charged with sexual battery with a firearm, robbery with a firearm, and kidnapping with a firearm. At this time, I'm going to appoint the Public Defender's Office to represent you. There is probable cause here for your arrest. Ms. May, did you wish to be heard?
Yes, Your Honor, to count 1, 2, and 3, all being punishable by life offenses, state asks that you hold him no bond pending an Arthur hearing.
No argument, Your Honor, pending the Arthur hearing.
All right, at this time, I will hold you with no bond because your offenses are charged as punishable by life offenses. However, even while you're in custody, you are not allowed to have any contact with the victim. Do you understand what no contact means?
Sí.
Yes.
All right, good luck, sir.
Thank you.
Sir, please tell me your name.
Fausto Chacón.
Fausto Chacón.
Sí.
Yes.
21 CF 526180. You're here charged with obscene communication. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond will be $2,500. You're not allowed to have any contact with any minor child under the age of 18. Do you understand that?
Thank you. Thank you. Gracias.
Thank you.
You're also not allowed to use any internet dating sites. Do you understand that?
Sí, lo entiendo.
Yes, I understand.
All right, good luck, sir.
Y me siento sucio y muy avergonzado lo que hice yo. Quiero que me perdonen.
I want to say that I feel dirty and that I feel very ashamed of what I did.
Por favor,
I
¿me
want to
pueden dejar aquí?
apologize.
Tengo una novia.
Thank you, sir.
Stop talking, please.
But before you say anything else, I want to advise you that everything you say is being recorded and can be used against you later. But the court appreciates your sentiment.
Okay, thank you.
Yes, sir. Good luck. Please tell me your name.
Jaime Bonet Rivera.
Jaime Bueno Rivera.
19 CF 11194. A warrant was issued for your arrest for violating your probation by using intoxicants to excess or possessing any drug or narcotic, by testing positive for cocaine, and by failing to undergo a drug and alcohol evaluation. There is no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Good luck, sir. Please tell me your name.
Rafael Alberto González Rivera.
Rafael Alberto González Rivera.
19 CF 8565. A warrant was issued for your arrest for violating your probation by changing your residence without first procuring the consent of the probation officer and by failing to comply with all instructions given in that you didn't report as instructed by phone. There's no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Good luck, sir.
Your Honor, Rockney Nizola, bonded.
All right. Is that it for Spanish interpreter cases? Thank you, Madam Interpreter. I believe that's all we need at this time.
Thank you, Your Honor.
Please tell me your name.
Teresa Brigham.
21MM3025. You're here charged with trespass on property after warning. There is probable cause. Did the state have an offer?
Yes, Your Honor. The offer was an adjudication credit time served, no return to the Orlando International Airport without a ticket.
Okay.
Was the public defender able to discuss that with her?
Yes, Your Honor. Me and Ms. Brigham spoke before court about the terms of the offer and the rights to be waived and the repercussions of that. The terms are adjudication of guilt, credit time served, and no return to Orlando International Airport without a ticket. And she would like to enter a plea of no contest today.
All right, Ms. Brigham, please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, you heard what the public defender just said to the court. As a friend of the court, I'm not appointing them at this time.
Okay.
Do you wish to change your plea today?
No.
You don't want to plead no contest or guilty?
I'm guilty because I know I did wrong, so.
Oh, okay, so that, you do want to enter that plea today?
Okay, no contest.
All right, you understand the rights you're giving up by entering a plea of guilty or no contest today?
No contest.
But do you understand the rights you're giving up?
Yeah.
You know we're not going to have a trial.
Okay.
You're giving up your right to remain silent and your right to testify on your own behalf. There will be no jury trial here. You understand that?
Yeah.
And that's what you want to do?
Yeah.
Do you have any questions for me about the rights you're giving up?
No, I don't.
You understand if you're on probation, this plea could violate that probation?
Okay.
You understand if you're not a U.S. citizen, this plea could deport you?
I'm a U.S. citizen.
All right. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your no contest plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the two days that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay them, and I'll order that you're not allowed to return to the Orlando airport without a ticket. Do you understand?
Yes.
All right, good luck, ma'am. Please tell me your name.
Albert James Berman.
21MM3068AO. You're here charged with open carrying of a weapon. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond is $1,000. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
At this time, I'm revoking your bond in 17 CF 12890 and 17 CF 12944AO. Your attorney's going to have to file a motion in front of those trial judges. Good luck, sir.
On me, English bonded, Your Honor.
Thank you.
Your Honor,
Your turn.
quick housekeeping matter regarding the Arthur hearing. I believe the sex crimes attorney is actually going to come handle it.
The what?
The sex crimes attorney that's assigned to the case is going to come handle the Arthur hearing.
Okay.
As well as the lead detective. He is on his way here as well. They were wondering if it was able for the state attorney to appear virtually. Is that possible in this courtroom?
I don't know the answer to that. I assume so.
Okay.
I don't know. If not, they can appear by phone. We have defense attorneys do that all the time.
I'm just worried about the phone. Sometimes it's very,
Yes, it's really difficult. They
If
can't
you-
drive here.
I am going to try, Your Honor.
We have all of this.
I told them probably like 3:30 is what it is looking like.
What time?
3:30,
I think that's,
generous.
yes. I appreciate your confidence that we can do this that quickly, but I'm not confident that we can.
Yes, Your Honor. Okay, thank you.
But we'll go as fast as we can, as reasonably as we can. Okay, please tell me your name.
Angelica Escalante.
21 271AW. You're here charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor. The offer from the state was adjudication of guilt, credit time served, and no return to 7-Eleven. I spoke with Ms. Escalante earlier before court, and we went over the terms of that plea deal, the rights that she would waive, and the repercussions of that. We spoke about the citizenship issue, the probational issue, and the other issues with entering a plea, and she still was agreeing to enter a plea of no contest.
All right, Ms. Escalante, please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You heard what the public defender just said as a friend of the court. You can put your hand down. Is it correct that you want to change your plea here today?
Yes, ma'am.
Has anyone threatened you or promised you anything other than the state's offer to get you to enter a plea today?
No, ma'am.
And you understand that you're giving up all those rights, we're not gonna have a jury trial.
Yes,
If you're not a US citizen, this could deport you.
Right.
All right. And you're not on probation out of state?
No, ma'am.
All right, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 1 day that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay them. Good luck. You have 30 days to appeal in writing. B. Can I just sign these at the end? Is that okay with you? I want to stop using hand sanitizer every other place.
Okay.
Because it gets all over everything. Please tell me your name.
Kyle Ferretti.
Good afternoon, sir. You're here in 21 3072, charged with violation of a county ordinance. There is probable cause for that arrest. And in 21 3065, you're charged with resisting an officer without violence and possession of drug paraphernalia. There's also probable cause for that arrest. Did the state have an offer?
Yes, Your Honor. The offer on the violation of county ordinance was an adjudication credit time served. The adjudication on the 21 3065 case was an adjudication credit time served as to the resisting and a no information as to the paraphernalia.
Did you have a chance to discuss that with him, Counselor?
Did, Your Honor. Me and Mr. Ferretti spoke earlier before court. We went over the plea terms that were offered from the state. I talked to him about the rights that he would waive as part of this plea deal. We spoke about citizenship and probationary status. And today he wants to enter a plea of no contest.
Mr. Ferretti, please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you, sir. You heard what the public defender just said as a friend of the court. Is that what you want to do here today?
Yes, ma'am.
All right, you understand all the rights you're giving up. Do you have any questions for me about those rights?
No, ma'am.
All right, how do you wish to plead to violating the county ordinance and resisting an officer without violence?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty on both of those charges and give you credit for the 2 days that you've been in jail. I have to order that you pay court costs. I'm going to reduce that to a lien. And at this time, I believe the state of Florida has an announcement to make.
Yes, Your Honor. The state announces a no information as to 21 3065 as to count 2 possession of drug paraphernalia. I'm following it up with a no information notice right now to give to the clerk.
Thank you. All right, good luck, sir. Please tell me your name.
Paul Louis Gaspard, Your Honor.
All right, in 21 3037, you're here charged with trespass on property after warning and disorderly conduct. There is probable cause. Is there an offer from the state?
Yes, Your Honor. The offer was an adjudication, credit time served, no return to the Orlando International Airport without a valid ticket.
Your Honor, may I be heard on bond conditions for Mr. Gaspard?
Yes.
He's visiting and he's on Social Security income. Would it be within your discretion to issue an ROR?
Your Honor, state would object due to him not being from the area, and not having ties to Orange County.
That is one concern for the court.
The bond would be too expensive for him. And we just request, as far as a non-monetary condition, to help out our client, we would request ROR.
Your Honor, respectfully, he was flying, which is an expensive task in and of itself. And he doesn't qualify for ROR, and I don't believe he qualifies for PTR either, due to his criminal history.
This was inside the airport?
I believe, yes, Your Honor, I believe he went in regarding the Dunkin' Donuts inside the airport.
Mr. Gaspard, where are you from?
Your Honor, I was born in Jamaica, Queens, New York, and I went to high school in Atlanta. I went to college in Polk County. But for the last 10 years, I've been a little unstable, and I just been blessed with SSI. So I returned to Orlando to find an apartment for me and my daughter, and that's where I was at the time, at the airport in the morning. I had bought a drink from the airport and from Dunkin'.
I'm not asking you about the
Sorry about that, Your
facts.
Honor. Sorry about
It's okay, listen, I'm telling you this for your benefit, not mine. You can say anything you want, but everything you say is being recorded and it can be used against you later. So the reason I asked where you're from is I'm trying to figure out what the best bond conditions are for you. I wasn't asking you about the facts.
Sorry.
That's why I stopped you. It's for your benefit.
I apologize.
It's all right, sir. Can he be screened for mental health pretrial release? Just based on some things I read in the affidavit and then a statement here today to the court that he was the last 10 years a little bit unstable. I'm gonna have you screened for mental health pretrial release, sir.
What, may I ask a question?
Your Honor, may we approach, please?
Yes. Hold on.
Your Honor, I'm just going to ask if I can have just a moment.
Yes, can we pass him? Is that okay?
Yep.
Thank you, Your Honor.
Yes, sir. We'll come back to your case.
Yes, yes, ma'am.
That way.
Please tell me your name, sir.
Brian Deshaun Simpson.
21MM3026AO. You're here charged with trespass in structure or conveyance. There is probable cause. Was there an offer from the state?
Not at this time, Your Honor.
All right.
Your Honor.
Yes. Hold on, let me appoint the public
are we
defender's
appointed?
office. Go ahead.
Are we appointed?
I'm sorry?
Did you appoint us?
Yes, I did.
Okay, thank you, Your Honor. Our client is homeless. He's been, I guess it's called housing instability. So I would request in consideration of that, a very low bond condition, perhaps even non-monetary, but if necessary, a very low monetary bond.
Your Honor, I don't believe he qualifies for PTR or ROR due to his history. The reason for the no offer was he just pled to a trespass less than a month ago. And I believe it was from the same area, and he's been trespassed from the same place at least 10 times, so he's been unable to follow court orders.
All right, sir. I'm going to reduce your bond to $250, but you can't go back to the airport. You understand that? All right, good luck, sir. Please tell me your name.
Kelvin Williams.
21MM2858. You're here charged with trespass on property after warning. A warrant was issued for your arrest. Another judge has already found probable cause. I'll appoint the public defender's office to represent you. Your bond will be $500. You're not allowed to return to 836 North Eola Drive. Do you understand that?
Yes, I understand that. I was told that the case was closed last night at pretrial.
I don't know what you're talking about. I have a warrant that was issued for your arrest. So I've appointed the public defender's office. They can look into that for you, but at this point, I don't see that the case is closed.
He has another trespass that's also not closed, but he may be confusing something with that one.
In 21MM2290AO, at this time, I'm revoking that ROR. It says ROR, but it also says the bond was $500, so I don't know which one it was. But I'm revoking that case, Counselor.
You're revoking the bond. Could you set it at a low monetary bond as well?
Your Honor, say has no objection to you issuing a new bond on that case. He has a very limited history, and all seem to be nonviolent offenses.
Where was that case? Where was that trespass? Is it the same location? Did you read the affidavit? This is an unusual trespass.
Okay, as far as I know, I was
I believe it was a different address, Your Honor. It was Colorado Ave.
It's what?
It was a different address, Your Honor, but it also very strange. I understand.
The facts are strange and concerning to this court.
Yes, Your Honor.
Also, for your consideration, Your Honor, he's also on Social Security income. If that has some effect on setting a new low monetary bond.
All right, I'll revoke that bond and set it at $500. Sir, don't go back to that address. You understand?
Yes.
Good luck.
How did I get two bonds?
Good luck, sir. Please tell me your name.
Joshua Zobo.
21 CT 167580. You're here to be arraigned on a charge of operating a motor vehicle without a valid driver's license. At this time, I'll appoint the Public Defender's Office to represent you.
Thank you, Your Honor. We're going to enter a plea of not guilty.
All right? It's an arraignment. You got to tell him the date.
Division 83, pretrial conference date will be June 28th at 9 a.m. courtroom 6C.
And then in case 20MM 281AE, a capias was issued for your arrest for failing to appear for a plea and sentence on a charge of criminal mischief and battery. The bond on that case is $1,500 each count, and I'll appoint the Public Defender's Office on that case as well. Good luck, sir. Please tell me your name.
Herbert Freeman, ma'am.
Sir, you're here charged with open container of an alcoholic beverage in 21 MO 520AO. Did the state have an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold and credit time served.
Did you have a chance to talk to him about that?
Ms. George did have a chance to speak with him prior to court. I believe she went over the terms of the plea offer, the rights that Mr. Freeman would waive in signing that plea offer.
Plea today?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am. No, Your Honor.
Oh, thank you. You can say ma'am. Has anyone threatened you or promised you anything to get you to enter this plea other than the state's offer?
No, ma'am.
All right, at this time, how do you wish to plead to open container of an alcoholic beverage?
No contest, ma'am.
All right, I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. Sir, I have to order that you pay court costs in this offense. Do you have a job?
No, ma'am.
Do you have a home?
Yes, ma'am.
All right, I'm going to reduce this to a lien.
Thank you.
Good luck, sir.
All right, thank you, ma'am.
You have 30 days to appeal in writing. Please tell me your name. What's your name?
State your name. Billy Higdon.
In 21 MO 521, you're here charged with open container of an alcoholic beverage and violation of state misdemeanors. It's a city ordinance. There is probable cause. Did the state have an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold and credit time served.
Okay.
Did either you or Ms. George have a chance to talk with him about that before court?
Ms. George did speak with Mr. Higdon about the plea terms and what rights would be waived in signing a plea. She's talked with him about the citizenship and probationary issues, and he would like to enter a plea of no contest.
All right, raise your right hand, please, sir.
Yes.
Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, you heard what he just said as a friend of the court. Is that what you'd like to do here today?
I didn't hear a word you said.
Did you hear that he said you want to enter a plea of no contest or guilty?
Yes, Judge, no
And-
contest.
And you understand the rights you're giving up?
Yes.
Do you have any questions for me about those rights?
No, Judge.
All right. Are you able to hear me okay?
I was not able to hear you. I did now, I did hear you.
You can hear me now,
Yes,
and you understand everything we're doing here today?
yes, Judge.
All right. At this time, how do you wish to plead to violating a city ordinance and open container of an alcoholic beverage?
No, that's why I'm here.
It is why you're here.
Oh, no contest.
You want to enter a plea of no contest
Yes, Judge.
and give up all those rights? We're not gonna have a jury trial, you're not gonna testify,
No.
you don't want any of that, right?
I'm gonna take the plea that,
Okay, you want to take the state's offer?
yes, Judge.
Okay, at this time, I'll withhold adjudication on both charges. I'll give you credit for the 2 days that you've been in jail. I'll order that you pay court costs. I'll give you a year to pay them. Do you understand, sir?
Yes,
Okay, you have 30 days to appeal in writing. Good luck.
okay.
Is this Mr. Gaspard?
Yes.
All right, 21 MM 303780. Ms. George, what are we doing with this case today?
He is going to accept the state's offer of an adjudication of guilt, credit time served and no return to, it looks like Orlando International Airport without a ticket. However, Your Honor, he would like to address you, understanding all the rights he would be given up once he accepts the state's offer here today.
All right, raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, so you heard what Ms. George just said. Is this what you want to do here today?
I do, Your Honor.
All right, and you understand all the rights you're giving up?
I don't.
Okay, you have the right to remain silent. You have the right to a jury trial when one is required. You have a right to force the state to prove the charges against you beyond all reasonable doubt. You have the right to call witnesses in your own defense. You have the right to have an attorney appointed for you if you can't afford to have an attorney. That attorney will help devise a defense strategy for you. You can call witnesses that would testify on your behalf. You're giving up all of those rights if you enter a plea today. We're not going to have a jury trial. You understand that?
I understand that.
And if you're on probation, this plea could violate that?
On probation?
I'm not saying you are, I'm saying if you are. I have to advise everyone of this.
I understand that.
Because you could be on probation in Michigan and I don't know it. So I have to tell you, if you're on probation, this plea would violate that.
Right, I understand that. I'm not on probation throughout the
All right, and you said you're from Jamaica, but I have to tell everyone, if you're not a US citizen, this plea could deport you.
I'm sorry to interrupt you. I'm not from the country, I mean, the Caribbean island of Jamaica. I'm from Jamaica, Queens, New York.
Oh, I'm sorry, I thought you said Jamaica. So, but I have to tell everyone, if you're not a US citizen, this plea could subject you to deportation.
Right.
You understand?
Yes, I am a U.S. citizen.
I thought so, but I still have to tell you that. All right, so what is it you'd like to tell the court?
Your Honor, I appreciate you explaining everything to me in detail, and the counsel was very informative on the offer that I was given. I have one last thing to say. I admit that I was maybe a little, my conduct was a little, tone-wise out of line, but I was just expressing my frustration from being told that I couldn't be somewhere where I purchased the item, and then I was thrown out of that place. So, and I made an agreement with the cops who was there to allow me to get on the bus. So it was only when they got tired of waiting for the bus that they told me that they was gonna arrest me. And that's how I got a trespassing charge. So I do feel like my disorderly conduct from the time I left Dunkin' Donuts to downstairs may have propelled some of this, because I was expressing myself, which the state will call disorderly conduct if it gets out of line. But this trespassing is something that I did not do, especially after I was able to purchase something from that establishment and was able to leave that establishment. And I just feel like it's hard for me to, take a plea, admit to doing something that I didn't do, you know what I mean? And
I understand.
And I really feel like I want to be accountable for my own actions, which I'm admitting to now, that my tone could have raised an issue with the cops, and that's why they gave me a disorderly conduct. So I'm accountable for that. But trespassing is something that I didn't do, and I know they don't have proof of, but I don't have the time to try to figure this thing out.
Well, I appreciate that, and this court very much respects someone who says, I want to take responsibility for my actions. I believe I should do the same thing, so I very much respect that you did that today in court. Unfortunately, as I am the court, I'm not the state, I can't drop that trespass charge. The state is the one that's charging you. So there's nothing I can do. I can't dismiss that charge. However, based on what you've said today, I'm inclined to withhold adjudication on the trespass.
Your Honor, for the record, state would object. He has a fairly lengthy history of convictions, a lot of which are adjudications.
I know. Thank you.
Your Honor, I would just say that that was 18 years ago. And given that my client is willing to accept responsibility for the disorderly conduct, we would just plead to the bench and ask that you withhold at least on the trespass, and he'll accept the adjudication of guilt on the disorderly conduct.
I'll tell you what, sir, this is pretty unusual for this judge, but I very much respect what you've done here today. So I'm going to withhold adjudication on both of those charges. I'll give you credit for the
2 days.
2 days that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay it. That's as long as I can give you. But I will order that you can't return to the airport without a valid ticket. So if you're flying, you can go there, but otherwise just don't go.
I respect that.
All right? You understand?
I respect that, and I definitely appreciate what you've done that you said is not normal. Because you're right now, you're using your heart to make a conscious, righteous decision in justice.
Yes, sir.
Appreciate that, Your Honor.
Good luck. I hope I don't see you again, not because you've been wonderful to deal with today, but I hope I don't see you again. And you have 30 days to appeal this in writing if you want to.
All right, and one last question. How much in court fees?
Did you say how much is court costs?
Yeah.
It's $274. $274.
That's like a fine?
It's not, it's just the court costs. I didn't impose a fine.
Right, I didn't hear you say anything about a fine.
No, I'm not fining you. I can fine you, but I'm not going to.
Right, I appreciate that.
Again, I respect that you took accountability for your actions, so I'm not imposing a fine, but I don't have a choice about the court costs. I have to impose that. I gave you a year to pay it. That's as long as I can give you.
Right, I respect that, and I appreciate that, Your Honor.
Yes, sir.
Right, have a blessed day.
Good luck.
Thank
You as well.
Thank you.
Who's next?
Mr. Minor refused.
All right. 21 MO 522. Counselor, it's a city ordinance case. Do you want to try to bring him back tomorrow? You can, I can find a willing waiver of his appearance today based on his refusal, but
Yes.
because it's a city ordinance case,
I will preface, yes, I would prefer he could come back tomorrow. However, Social Security disability for 52 years, these kinds of offenses kind of usually indicate some issues with housing instability and financial instability. So if you are so inclined, we can bring him back tomorrow. But if you can set a low monetary bond, I would be open to that discussion as well.
Your Honor?
he has a really low monetary bond. It's up to you. I'm offering to reset it so that he has the opportunity to enter a plea if he would be inclined to do that tomorrow, and then he'd be released without having to post the monetary bond, but
That's fine, Your Honor.
That's up to you.
We can do that.
all right. So we'll reset him for tomorrow.
Thank you, Your Honor.
I'm staying his bond, so he could bond out if he posts those. I'm not increasing it.
I appreciate that. Thank you.
Please tell me your name.
Deontay Anderson.
A capias was issued for your arrest in 20 CF 12979AO, charging you with, failing to appear for arraignment on a charge of burglary of a structure and grand theft. There is no bond authorized, and I'll appoint the public defender's office to represent you. Good luck. You can say anything you want, but everything you say is being recorded and can be used against you. So did you have a question?
So
Just get close to the microphone.
my address changed, and I recently just started an engineering program, and I have a job at McLean. So I was wondering, I wasn't running, I was working at the time, and I was on the phone with the clerks of court.
So I believe everything you're saying, but because it's a capias signed by another judge, I can't change it. So call the number on that paper for the public defender's office, and they can set a bond motion in front of your trial judge, who's the only one who can change that capias. So call that number right away.
You said I basically have to talk to the judge of this case?
Right.
Thank
Good luck, sir. Please tell me your name.
Eimantas Benavichus.
#21 CF 524680. You're here charged with resisting an officer with violence, battery, and disorderly conduct at a public establishment. I'm going to appoint the public defender's office to represent you in this case.
Your Honor, our client's employed full-time, has no history here in Florida or other states, and he does qualify for PTO.
There is probable cause. Thank you, counselor. What says the state?
Your Honor, he otherwise qualifies for PTR, so state has no objection.
All right, I'll place you on pretrial release with special conditions. You're not allowed to return to this location, Rocco's Tacos. Do you understand?
Yes, ma'am.
You're also not allowed to possess or consume alcoholic beverages or controlled substances without a valid prescription, and you'll be subject to random drug and alcohol screens. Do you understand?
Okay.
You're not allowed to have any contact with the victim. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Your Honor, are you doing random urinalysis with the no drugs or alcohol?
Yes. Said that?
Bello Rivera, bonded, Your Honor.
All right. Please tell me your name.
Name is Sean Ingram.
A warrant was issued for your arrest in 21 CF 526280 for first-degree murder with a firearm. Another judge has already found probable cause. I'll appoint the public defender's office to represent you. Yes, Ms. May?
Your Honor, as this is a first-degree murder and a punishable life offense, state is asking for no bond pending an Arthur hearing.
I will do that. At this time, there'll be no bond on your case, but even while you're in custody, I'm going to order that you're not allowed to have any contact with the victim's family members. Do you understand?
Yes, ma'am.
Good luck. Please tell me your name.
Mark, first name, last name Gandera.
18 CF 15601. A capias was issued for your arrest for failing to appear for a violation of probation hearing on a charge of robbery, sudden snatching. There is no bond authorized on this capias, and I'll appoint the public defender's office to represent you. Good luck, sir.
Thank you so much. Alfonso Harvey, refuse, Your Honor.
All right. 21 MM 179. He's charged with resisting an officer without violence. There is probable cause. I'll appoint the public defender's office. His bond is $500. And I find his refusal a willing waiver of his appearance today. In 21 CF 5218, he's charged with petty theft, 2 or more prior convictions. Again, I find his refusal to come to court a willing waiver of his appearance. There is also probable cause in this case. I'll appoint the public defender's office to represent him, and he's not allowed to return to Walmart at 1700 South Orange Blossom Trail.
Are you staying the bond, Your Honor?
Oh, yes. Thank you. Please tell me your name.
My name is Michael James Holokai, ma'am.
21 CF 5248AO, you're here charged with armed trespass in an occupied structure and resisting an officer without violence. There is probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Your bond is $1,000 on count 1, $500 on count 2. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the target at 2155 West Town Center Boulevard. Do you understand?
Yes, ma'am.
Any other conditions the state would request?
No weapons, Your Honor. Oh, you already got it.
I thought I said that.
You did, I'm sorry.
All right. Good luck, sir. Please tell me your name.
Moses Danielle James.
A capias was issued for your arrest in 20 CF 14776 for failing to appear for arraignment on a charge of grand theft. There is no bond authorized on that capias, and I'll appoint the Public Defender's Office to represent you. In 20 CF 3143, a warrant was issued for your arrest out of Lake County on a charge of grand theft. The bond is $2,000 and will notify Lake County that you're here. Good luck, sir. I don't understand that sound. Please tell me your name.
Shannon Johnson, ma'am.
A warrant was issued for your arrest in 21 CF 5263. Another judge has already found probable cause in that case, charging you with possession of cocaine. Your bond is $1,000. You're not allowed to possess or consume any controlled substance without a valid prescription. You're not allowed to possess a weapon of any kind, firearm, or ammunition, or have contact with any known drug dealers. I'll also appoint the Public Defender's Office to represent you. In 21 CF 5238, you're here charged with possession of a counterfeit substance with intent to sell. I'm going to appoint the Public Defender's Office to represent you. Ms. George, did you review this probable cause affidavit? Or one of you?
Briefly, Your Honor. I would just, on the charge, it's a nonviolent offense. I would ask not to revoke, but just to set.
No, Your Honor, can we have just a moment?
Yes. Let me just ask the state.
Thank you, Your
If the state can show the court, what's the probable cause for the possession with intent to sell?
Yes, Your Honor. For the statute,
That's what I'm asking right now.
the officer notes in his affidavit that he had more than what a normal personal use would be.
Okay.
Sir, let me just tell you this. Everything you say is being recorded and can be used against you later. So it's okay. You can say anything you want, but I'm appointing the Public Defender's Office and they might want to talk to you about what you say because it's being recorded. And then the state can pull this record and use it against you later.
Yes, ma'am, I'm sorry.
That's why. Yes, Ms. May?
To the intent part, it was one, that the amount of pieces he had, the officer deemed that was not generally, it's more than generally you would have for personal use. He also stated that he didn't have any way to ingest the narcotics that he had in him or had with him, which he also determined to not be standard for personal daily use. And given that it was fake or counterfeited, the officer used his training and experience to determine that he was likely trying to sell it since it was a large amount, more than personal use, and he didn't have any way to actually ingest it himself.
Your Honor, I did read this arrest affidavit, and for the officer to write, it's uncommon to have that few. I mean, over a little that it wouldn't be, but then under the amount he usually see, even the arresting officer is questioning probable cause. I know they still wrote the arrest affidavit and arrested our client, but I would challenge PC on that.
Ms. May?
I would also argue that he didn't even have a cracked pipe in his possession, so I don't see any PC.
I believe that goes towards the intent to sell, Your Honor, not the intent of personal use, that he didn't have a way to ingest it himself.
I think it does. And I'll grant you it's been 10 years since I did this on that side of the bench. But there was some case law I don't know, 10 or 15 years ago, that just the amount wasn't sufficient for intent to sell. Can either party tell me about case law currently? Is there anything more current that says that?
Your Honor, I don't have case law currently, but if you're not inclined to find PC, stay with us for 24 hours.
So I definitely believe there's PC in this affidavit. There's probable cause to believe that the defendant possessed
A
counterfeit cocaine.
Yes, Your Honor.
This court is not convinced there's probable cause that it's possession with intent. So if you want 24 hours, I'll give it to you, or if you want me to just find probable cause for the possession, I'll do that.
Your Honor, I'd prefer 24 hours just to talk to the officer.
All right, I'll give you that. All right, as to 21 CF 4083, you're out on bond for another possession of cocaine charge. At this time, I'm inclined to revoke that bond unless your attorneys can give me a reason not to.
Your Honor, he has multiple failures to appear, a rather lengthy history, including violent offenses, and the charge that he's out on is possession of cocaine. He has a current warrant for possession of cocaine and a current case of counterfeit cocaine. Stay with us that you revoke.
Your Honor, I would seek just a change in bond. It's a nonviolent offense. Our client is saying he's trying to seek help. And I understand you changing the bond issued on the case he's out on bond in, but I would also ask not to revoke, but to set just a different monetary bond.
Counselor, I'm not inclined to do that. One of the purposes of bond is to ensure that they won't commit new law offenses. I can't, this court is struggling to find any reasonable conditions of bond that I can place on your client that will stop him from possessing cocaine. He's out on bond for it, he's arrested for another case and another one.
I understand, Your Honor, but when it comes to drug abuse, if someone is trying to stop, there's also the overwhelming drive to start as well. And so I would have you consider the mental and physical aspects of drug abuse in your decision.
Your Honor, I would just point to the fact that he is employed part-time currently, and I see that his last failure to appear was in 2015. His last conviction was a drug paraphernalia charge in 2017. Understanding this is a warrant, and he did pick up another charge for possession of cocaine. Being that it's a nonviolent offense, and I believe that even with the warrant, it's a very small amount of cocaine, I would just ask that you revoke and double the bond as opposed to revoking and setting it at no bond in this case.
I am not typically inclined to do that, but it does appear in the affidavit for the warrant that he was cooperative with law enforcement. So given that fact, and based on the arguments of your attorney today, at this time, what I'm going to do is revoke your bond and double it. So that bond in that case will now be $2,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Correction, Your Honor, his bond stayed on the 5238 AO case as well.
Stayed until tomorrow in case he wants to bond before PC.
Oh, yes, it stays. They have 24 hours.
Okay.
But I'm not changing that bond. Please tell me your name. In 21 CF 5265, you're here charged with 2 counts of failing to, well, 1 count of failing to report to the driver's license office your change of address as a sex offender, and 1 count of failing to report after vacating residence as a sex offender. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $15,000 on count 1 and $150 on count 2. You must maintain your sex offender reporting requirements. Do you understand?
Yes, ma'am.
In 21 MM 3046AO, you're here charged with resisting an officer without violence, stalking, voyeurism, assault, and battery. There is probable cause, and I'll appoint the public defender's office to represent you. Ms. May, did you wish to be heard?
Yes, Your Honor, when setting bond on all these charges, the facts in the case are pretty egregious regarding the defendant's own sister and the things that she has witnessed and heard and told law enforcement regarding these charges. And given that he is a registered sex offender, I'd ask that you take that into account when setting bond on these charges and take into account the proximity of the victim to the defendant in this case. I believe the victim reported that she has to walk past the defendant's apartment to get to her own, further creating an issue between the two parties. So I'd ask you to take that into account when setting bond, as it's not a general like assault or battery.
Counselor, I agree with you.
Your Honor, I understand what the state has proposed, and we would still argue for just a reasonable.
I can't hear you, Counselor.
We would just argue for a reasonable bond condition. We understand what the state has proposed as well, for your discretion.
Your bond on count 1 will be $500. Count 2 will be $5,000. Count 3 will be $2,500. Count 4 will be $2,500. And count 5 will be $5,000. You're not allowed to have any contact with the victim in this case. Do you understand what no contact means?
Yes, ma'am.
You can't speak to her. You can't send a message to her through friends or family. You can't contact her on social media. You can't send a text message. If she's walking by your apartment, you can't say anything to her. Do you understand that?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to have any unsupervised contact with any minor child under the age of 18. Do you understand?
Yes, ma'am. May I say something, Your Honor?
You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that? Yes, sir.
Where all these assault charges, stalking charges come from? I've been to this place 2 years. Now, how all this stuff coming up on?
State, put the factual basis on the record, please.
Come on, pull your mask up for me.
On or about May 5th, 2021, law enforcement arrived to the victim's address. The victim told the officer that she got in her car, looked up and saw the suspect watching her from the side of the building. He ran towards her car and threw rocks at her windshield. He then tried to get into the vehicle, touching the passenger side. She was able to pull away. The victim called the defendant's sister. In the background, the defendant said some profanity towards the victim. About 30 days prior to that, the defendant came from around the dumpster, grabbed the victim in a chokehold, and attempted to pull her pants down. She started to scream and resisted him by pulling her pants up. She was able to wrestle him and get away and get to her vehicle. The victim also noted that he lives next door to her. She has seen him peeking through her bathroom window while she showers on more than one occasion, and has to turn off the lights when she showers because she is afraid that he is watching her. The defendant's sister also noted that she has seen, or the defendant's daughter has seen him peeking into women's windows. All events occur in Orange County, Florida.
Right, and so I think that's sufficient. Also, sir, you're not allowed to go to the victim's residence for any reason. Do you understand that? Sir, do you understand? All right, are there any other conditions the state would request?
No, Your Honor.
Good luck. Please tell me your name.
Isaac Maldonado.
20 CF 15193AO. A capias was issued for your arrest for failing to appear for a pretrial conference on a charge of burglary of a structure and petty theft. There's no bond authorized on that warrant, and I'll appoint the public defender's office to represent you.
Can I explain?
So you can say anything you want. Everything you say is being recorded and can be used against you. But this is a capias that was signed by another judge, so I can't change it anyway. What you should do is call the number on that paper and explain it to your attorney.
You gotta take any action on the out-on bond.
No.
On the record.
What? I will. I'm just waiting until they get done. And I'm taking no action on his out-on-bond case.
Thank you, Your Honor.
Marcelin is in the hospital, Your Honor.
21 CF 5243, I'll appoint the public defender's office.
We'll waive his appearance, Your Honor.
All right. There is probable cause. His bond is $2,500. No contact with the victim. I'm sorry, not return. Not the victim. He's not allowed to return to 2507 North Hiawassee Road. Please tell me your name.
Tyrese Newton.
21 CF 5216AO. You're here charged with robbery by sudden snatching. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond is $1,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You're also not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Your Honor, Mr. Orr is in the hospital.
21 CF 5245. I'll appoint the public defender's office.
We'll waive the appearance, Your Honor.
All right, there is probable cause. I'll stay the bonds at $1,000 on count one, $100 on each subsequent count. She's not allowed to return to Polo Ralph Lauren at 4959 International Drive.
Your Honor.
I'm sorry?
Could I ask a question of PT, pretrial services? Her report came back, like everything was missing. I didn't know if they had a chance to interview her, and will they?
With who?
Will you interview Miss Orr? Okay. Will she be interviewed after? Oh, hospital. Okay. Gotcha. Thank you.
Jeremy Shelton, reviews, Your Honor.
All right. 21 CF 5250, I'll appoint the public defender's office. I find his refusal to come to court a willing waiver of his appearance today. There is probable cause. I'll stay his bond at $1,000. In 21 CF 5249, again, I find his refusal to come to court a willing waiver of his appearance today. I do find probable cause, and I'll appoint the public defender's office. His bond is $1,000. He's not allowed to possess or consume controlled substances without a valid prescription or have contact with any known drug dealers. At this time, I'm revoking his bonds and his two out-on-bond cases.
Your Honor, I believe he has a third case.
Hold on. I missed a tab. 21 CT 3304, 21 CT 3305. Driving while license suspended and expired driver's license, more than 6 months. There is probable cause. I find his refusal to come to court a willing waiver of his appearance, and I'll appoint the public defender's office to represent him.
Are you staying those two bonds, Your Honor?
Yes.
And you said you were revoking his out-on bond.
Yes. Please tell me your name.
Jeffrey Stevens.
21 CF 5242AO. You're here charged with tampering with a witness to hinder communication to law enforcement. I'm going to appoint the public defender's office to represent you. There is probable cause in this case.
Your Honor.
Yes.
If we could, According to the arrest affidavit, there's intoxication involved on both sides. If you could just ask for reasonable bond conditions in your discretion.
I'll stay your bond at $1,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? You're also not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume any alcoholic beverages. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Milagros Tejada.
21 CF 5244AO. You're here charged with carrying a concealed firearm. I'm going to appoint the Public Defender's Office to represent you.
Okay.
There is probable cause in this case. Your bond will be $2,500. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
You're also not allowed to have any contact with the co-defendant, Albert Berman. Do you understand what no contact means?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Your Honor, may I be heard on the condition you set?
Yes.
Our client's been unemployed for 2 years. No criminal history here in Florida or any other state. I would ask for a lower monetary bond. The unemployed usually are struggling financially. I would appreciate that.
What says the state?
Your Honor, I believe the bond is reasonable, given a firearm was included in this offense.
It was not discharged. There's no alleged victim. And again, the financial reasons, I would request a lower monetary bond.
Your Honor, she can qualify for pretrial release.
She would?
She could.
Does the state object to pretrial release?
No, Your Honor.
All right, I'll place her on pretrial release. Same special conditions as the bond conditions. All right, good luck, ma'am.
Thank you.
We're getting close, counselor. Please tell me your name.
Ernest Tillman.
A capias was issued for your arrest in 21 CF 4812 for grand theft. The bond is $4,000. You're not allowed to have any contact with the victim. I'm sorry?
I don't know who it is.
I don't have that in front of me. Does the state have it?
Yes.
I only have the capias.
1 second.
And you're not allowed to return to the scene of the offense. But the state's going to tell us who the victim is.
Mark Dean.
Did you hear that?
Yes, ma'am.
All right. So that's who you can't have any contact with. I also have, oh, maybe I do have that. Hold on a second. No. Oh, he's out on bond in 20 CF 7485. Can the state advise the date of the offense that led to the capias?
Yeah, sure. The date of offense was November 12th of 2019.
Of 2019?
Yes, Your Honor.
All right, then I'll take no action and is out on bond case. Good luck, sir.
Thank you.
Yes, sir.
Jeffrey Todd.
Thank you. 21 CF 525280, you're here charged with aggravated assault with a firearm.
Your Honor, the way it was charged, it came in as aggravated assault with a firearm on a code inspector, the way the statute came in. State would ask that you find aggravated assault with a firearm, which is just basic, 784.021 sub 1 sub A. And since it's a lesser included, it shouldn't be a problem, Your Honor.
I was going to ask you about that.
Yes, Your Honor, I believe the officer just clicked a statute down or something.
There is probable cause for aggravated assault with a firearm. I'll appoint the public defender's office to represent you. Your bond is $2,500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am. Could you tell me the victim's name, because I honestly don't know.
Yes. Does the state have the victim's name?
Yes, Your Honor.
Could you write the name down?
It'll be on your paperwork.
The victim is Dustin Randolph.
That's who you can't have any contact with. You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name. 21MM 3064, you're here charged with possession of drug paraphernalia. I'm going to appoint the public defender's office to represent you. There is probable cause. Your bond is $500. You're not allowed to possess or consume any controlled substances without a valid prescription, and you can't have contact with any known drug dealers. Do you understand? In 21 CF 5240, you're here charged with battery with 2 priors. I'm going to appoint the public defender's office to represent you in this case as well. There is probable cause. Your bond is $2,500. You're not allowed to have any contact with the victim. Do you understand what no contact means? You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck, sir. Please tell me your name.
Ernest Chester Tweedy.
20 CF 1266880. A capias was issued for your arrest for failing to appear for arraignment on charges of burglary of a dwelling and petty theft. There's no bond authorized on the burglary of a dwelling and $500 on the petty theft. I'll appoint the public defender's office to represent you. Yes, Ms. George? Okay, I thought you wanted to be heard.
On the bottom.
Thank you.
It says right on the bond reinstated on the website.
Your Honor, just to advise the court, my client during the time that this failure to appear was issued, he was actually incarcerated in Seminole County at the time. There was a motion filed by our office, but the judge denied it. It appears he wants to see him prior to being released.
Denied part of it.
He didn't deny. He granted setting aside the bond, but he did not grant squashing the capias. So
Orange County sent me to Seminole County. I was here for a month before I was sent over there, and then I was sent there. I didn't violate my bond that I was on. I bonded out, and Seminole revoked the bond I was on for a year, and they picked me up. Y'all sent me there, and I had court 9 days later.
All right, hold on one second. Ms. George, can you print all of that? Do you have the motion and the order from the judge?
Yes, I have the order open right now, Your Honor.
If you can print, because
Yeah, if you can get me that, let me look at it.
It was, they granted setting aside the bond, Patricia, and denied quashing the capias. So the capias is still active.
Oh, they denied quashing the capias.
Denied
Oh.
quashing
Did it in
So
part, Your
I would
Honor.
ask that it stay at no.
All right, so I can't do anything about that because it's a capias that was signed by another judge, so I can't change it. I believe what you're telling me here today, but I can't change it. So
Why would they reinstate the bond without watching the capias? I mean, it's on the clerk of the court website. It was granted, the bonds reinstated, both bonds.
I believe from my notes, the judge wants to see him.
that's what it looks like.
It says to appear before him once he's released from Seminole. So that, I believe that's why he did not quash the capias.
So I can't change that because of what it is. But since your attorney knows what's happening, they'll try to get you in front of the judge as soon as they can. I just can't change that judge's capias.
Anything to happen. How far am I gonna be set off? Because my attorney ain't doing nothing for me.
Well, they filed the motion.
That's all he's done. That's it. And he's been my attorney since the beginning of the year.
I will.
I don't know, sir.
I'll let him know that you're here.
Okay, thank you.
When is my court date?
I don't have a court date for you. Please tell me your name.
DeMarcus what?
A warrant was issued for your arrest in 20 CF 7100 for aggravated battery with a weapon and battery. Another judge has already found probable cause in this case. I'll appoint the public defender's office to represent you. Yes, sir, did you wish to be heard?
Yes, on bond conditions, Your Honor.
All right.
Our client, if you've read the arrest affidavit or the story behind the affidavit, it's a confusing mess of testimony. I got lost in all the characters. Our client is unemployed, he's in college. We would ask for, if you're inclined, a lower monetary bond than usual because of those details, in your discretion, of course.
What says the state, Ms. May?
Your Honor, the judge, signing the warrant granted a $10,000 bond on the battery, and left it up, the aggravated battery with a weapon up to, Your Honor. I think it holds some weight that the judge granted $10,000 on a standard battery with what they intended for you to grant on an aggravated battery with a weapon. I'd also just point to Mr. White's history. There seems to be a lot of violent offenses, a lot of batteries. I should take that into account when setting the aggravated battery bond amount.
Again, Your Honor, an unattainable bond is tantamount to no bond at all. So if you would consider that.
Your Honor, it also looks like he is from out of state. So that's for a bond that will secure his presence.
What bond is the state asking for?
Your Honor, as the warrant signing judge granted $10,000 on the battery, I'd ask for more than 10 on the aggravated battery with a weapon, as it is a higher enhanced charge.
Again, I echo my thoughts, Your Honor, about high bonds being unattainable.
I appreciate the arguments from both attorneys. I do share the concern of the state, however, that he is just here visiting and lives in California. At this time, your bond will be $15,000 on count 1. I'll stay the bond at $10,000 on count 2. You're not allowed to have any contact with any victim, witness, or co-defendant in this case. Do you understand? You have to answer out loud.
Yes.
Do you understand what no contact means?
Yes.
I'll also order that you're not allowed to possess a weapon of any kind, firearm, or ammunition. Did this occur at your mother's house? Where you were staying?
I don't even know why.
I can't hear you. Get close to the mic.
I don't even know why I have a warrant. I'm confused myself.
All right, I'll have the state put the factual basis on the record.
Yes, Your Honor. On or about May 31st of 2020, Ms. LeGrier and Mr. Reeves were traveling home from a party, talking and taking another friend home. When they stopped at a traffic light, while waiting for it to change, someone hurled an unknown object that struck the driver's side window of LeGrier's Toyota Tacoma.
I can't hear you at all, so I imagine he can't.
They were stopped at a light. Someone
it.
threw something that hit the vehicle. Instead of notifying law enforcement, LeGrier and Reeves followed the vehicle home and exited the truck to confront them. DeRoches and Mr. White and others from the Dodge attacked Reeves, during which the defendant applied a chokehold and rendered Reeves unconscious. In an attempt to aid him, LeGrier grabbed a golf club from the rear of the truck. DeRoches disarmed LeGrier, and the other two ended up fighting, grappling on the ground. Reeves became unconscious, and the defendant grabbed the golf club and began repeatedly striking LeGrier on the head and back. All events occurred in Orange County, Florida.
Your Honor, I have no recollection of anything she's saying. I don't even know what she's talking about.
All right, so
Your Honor, like I said, when I read the affidavit, I didn't even see our client's name mentioned until the very end. I don't know where he got dragged in. And again, the bond amount, even half of the ordered bond amount could keep someone here.
his name is at the end, counselor, but his description is throughout. He meets the description.
It just confused me because there's 6 to 10 characters
Right.
being described, and then I finally see our client's name, and I go, how does he fit into all this? It's a confusing mess, and so that's why I argue for a lower monetary bond due to his financial situation. He's in college, and I would have you consider that in your order.
Yes, Ms. May?
Nothing, Your Honor.
Oh, you're standing. I thought that meant you wanted to say something.
No, Your Honor. I just anticipated argument.
I agree with you. There's a lot going on here, and there are many players. There also could be more charges that come from this, just reading what's in the affidavit. All right, here's what I'm going to do. I'll reduce count 1 to 10,000, but it's going to be 10,000 on each with all of those same conditions. Are there any other conditions the state would request?
No return, Your Honor.
To where?
No return to 2227 West Pine Street, Orlando, Florida.
Is that where your mother lives?
Could you say that again, please?
2227 West Pine Street.
I don't know that address.
Okay.
I don't know that
So
address.
you shouldn't have, don't go back there. You shouldn't have any trouble with that if that's not where your mother lives.
What is that? I don't know what the address is.
Your Honor, that's the victim's address.
Right. I just wanted to make sure he wasn't going to tell me his mother lives there. All right. Good luck, sir.
Yes.
You were close, Ms. May.
I guess 3:30, but you never know.
We had 60.
That's pretty close. Just out of county and warrants.
I thought 3:30 was a bit optimistic. Please tell me your name.
Damian Carpenter.
2016 CF 12489. You're here because a warrant was issued for your arrest for violating your community control by failing to live without violating any law, by being arrested for the criminal offense of transportation to building for prostitution in Osceola County on October 28th, 2020. There's no bond authorized on that, and I'll appoint the Public Defender's Office to represent you. Good luck. Please tell me your name.
Sean Hindy.
A warrant was issued for your arrest in 17 CF 362AO for violating your probation by using intoxicants to access or possessing any drug or narcotic, to wit, you tested positive for cocaine. There's no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Good luck, sir. Please tell me your name.
Carrie Lesson.
A warrant was issued for your arrest for violating your probation in 15 CF 15897. There's no bond authorized on that, and I'll appoint the Public Defender's Office to represent you. In 21 CF 5239AO, you're here charged with possession of cannabis with intent to sell and possession of cannabis under 20 grams. Did you say something? I'll appoint the Public Defender's Office to represent you in this case as well. There is probable cause. Your bond is $1,000 on count one, $100 on count two. You're not allowed to possess or consume any controlled substance without a valid prescription. You're not allowed to have contact with any known drug dealers, and you're not allowed to have contact with any of the witnesses in this case. As to 20 CT 2174AO, you're out on bond for a reckless driving.
Your Honor, I believe he has a private attorney on that case.
I think he does.
Your Honor, if you're inclined to revoke, I just ask that you set a higher bond.
All right, I'll take no action in that case at this time. Good luck, sir. Please tell me your name. A warrant was issued for your arrest in 21 CF 3238 for grand theft of a motor vehicle. Another judge has already found probable cause. Your bond is $2,500. You're not allowed to have any contact with the victim. In 20 CF 2724, a warrant was issued for your arrest for violating your probation by committing the new law offense of grand theft, petty theft, loitering or prowling, and resisting an officer without violence. There's no bond authorized on that warrant, and I'll appoint the Public Defender's Office to represent you. Good luck.
Antasia Anderson bonded, Your Honor.
Thank you. Please tell me your name.
Keon Brown.
Looks like you have out-of-county warrants. 20 CF 4870 is a warrant out of Marion County for aggravated assault with a deadly weapon and battery, second offense. There's no bond authorized on that. I'll appoint the Public Defender's Office to represent you, and we'll notify them that you're here. In 2017 MM 6102, a warrant was issued for your arrest for failing to appear for a battery charge. Your bond is $1,013. That's out of Pasco County. We'll also notify them that you're here. Good luck, sir.
Tina Dixon bonded, Your Honor.
That one.
Just say that one.
Please tell me your name.
Samuel Light.
You have a warrant out of Seminole County in 18 CF 3426 for violating your probation for 2 counts of leaving the scene of a crash resulting in injury, driving a motor vehicle without a valid license. There is no bond authorized on that. I'll appoint the Public Defender's Office to represent you, and we'll notify them that you're here. Good luck. Yes, sir.
When, do they have a certain time limit to come and get me or no?
Well, because of coronavirus, it sort of suspended all of those time limits. Some counties even stopped transporting for a long time, but now everyone is transporting, so I can't really give you a time. What county is this? What did I say?
The reason I
It's
asked,
Seminole County. They're transporting. They'll come and get you.
okay, the reason I was asking, if I have a few seconds, is I go to school full-time online and I work. I just started this job Thursday. It's like, this is just, my whole point is to pay off my PO, and that's what she told me yesterday, and I wind up getting arrested anyway. So I have the money on my debit card to pay off my PO fines and all that stuff, but I wasn't given an opportunity to do that.
You're gonna have to talk to her and that judge. It's another judge's warrant, and I can't change it.
Yes, ma'am.
But I appointed our public defender to represent you, so call them right away, because maybe they can get you in front of that judge quickly.
All right.
All right, good luck, sir.
Mr. McFall bonded.
Please tell me your name.
James Smith.
All right, you're here because a warrant was issued for your arrest.
Marion County, yes.
And yes, in Marion County.
It's been several times that I had came before the judge, and they RR'd me, and Marion County never came and got me.
So all I have is there's a bench warrant for failing to appear for arraignment on a charge of no valid driver's license. The bond is $500, so you have a bond. If you can post that, you can bond out. But if not, we'll notify them that you're here and they'll transport you.
Okay, Your Honor, would I be able to get a
I can't hear you.
would I be able to get a smaller bond if possible?
I can't change that because it's another county judge warrant.
Okay, because they never came and got me two or three other times that I was here. They,
Marion County didn't?
yes, ma'am. It's in the records. I say around September.
I believe you. I believe that you're telling me the truth.
Around September and around December, I have got locked up. And when I had bonded out and they also RR'd me, I was never received a court date. The last court date I had for Marion County was April 16th of 2020. And their whole judicial system was closed through coronavirus. I was supposed to come this direction.
It was.
To start working. And I was working for Popeyes and Church's Chicken. Due to me cleaning up my old background, I'm now just working for Popeyes. I do work, and I'm trying to catch up on my lawyer fees, my court fees, court costs, and everything.
I believe you, sir. I can't change that at this time, but you do have a bond.
Yes,
So if you're able to post it, you can bond out and you don't have to wait for them to come and get you. But call the number on that green piece of paper because I appointed our public defender to represent you here, so you don't have to wait to get to Marion County to talk to an attorney.
Okay, so how soon will Marion County be able to come get me? Or-
I don't know the answer to that,
Okay, God bless you. Thank
but I'll contact them myself as well. Good luck, sir. All right. Is everybody ready for Donald Garrell?
Yes, Your Honor. Good afternoon.
Good afternoon. This is case number 21 CF 4802. Oh, let me move that.
Thank you so much for recalling this case, Your Honor.
Yes. And I apologize that you had to sit here through all of that, but at least I hope you got some work done while you were back there. But if we're ready to proceed. I'm ready.
Yes, Your Honor, the state has a witness to present. It is Detective Wesley Avant. If I can call him, if he can stand at this podium, would that be okay?
Yes.
Thank you.
I assume that mic works. We'll find out.
Good afternoon, Your Honor.
Good afternoon. Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Detective Wesley Avant, Orange County Sheriff's Office.
And Detective Avant, are you the lead detective on this case?
I am.
And when did you become involved?
Sometime in October last year, I can give you an exact date. On November 12th, 2020, I was assigned this case.
November 12th of 2020?
Yes.
Okay, and was there a call that originated and started this investigation?
Yes.
What was that call?
The victim's mother called and notified the Orange County Sheriff's Office that she had found among the belongings of a cousin a particular item that caused her concern.
Can you just speak up a little bit into the microphone?
Yeah, I'm trying.
I'm sorry, the masks make it really
Yes,
difficult for
they do.
everyone, so you just have to speak up.
I've rarely been accused of being too quiet, so
It's the
it
masks.
shouldn't be an issue. She found a particular item among her cousin's belongings while he was incarcerated in the Seminole County Jail that caused her concern. She then spoke to her child, her daughter, and the daughter disclosed an incident of lewd conduct and a lewd molestation by the same cousin.
Okay, and so the woman who you're speaking of, who you mentioned is the victim's mother, is that Ashley Gibney?
That is correct.
Okay, and you stated that she had heard through her 6-year-old daughter that her cousin had molested her 6-year-old daughter.
That is correct.
Okay, and so the relationship between Ashley Gibney and the defendant is that they're cousins?
From my understanding, yes.
Okay. And what did the victim's mother explain that her daughter had disclosed to her?
That the defendant, while laying on the couch in the living room, had asked the child to remove her clothing and shake her butt in his face, and then to wipe her butt on his face.
And was there actual, let me scratch that question. Let's back up for a second. Did the defendant and Ashley Gibney, as well as the victim, all live together at the time of these allegations?
At the time of the allegations, yes.
Okay, and they lived at the victim's address?
That's correct.
How old was the victim when you became involved in this case?
5 at the time.
And when did she turn 6?
On December 21st.
So she would have been 5 when the lewd molestation and or lewd conduct took place, and then she was 6 when the investigation really got started?
Correct.
Okay. At some point, did you execute a search of the residence?
I responded to the residence and collected an item that was left by the defendant in the residence.
And that was the victim's address, correct?
Correct.
And what was that item?
A childlike sex doll.
Where was this childlike sex doll found?
By the time I got it, she had moved it to the living room, or to the trunk of her car from the living room. She wanted it out of her house so that her daughter wouldn't find it, but it was contained inside of a cardboard box.
Okay, and so what else besides the sex doll was in that box?
There was lingerie that would fit a child, a wig, items that were clearly used to clean the doll, and some other I guess instructions you would call it, but it was in Chinese, written in Chinese, as well as a invoice and a shipping label.
And what information was contained on that shipping label?
That it was addressed to Donald Gorell at an address on Drake Drive where at the time his mother lived. His name was on it. It shipped from a province in China and appeared to have been paid for through the internet for approximately $500.
And did you actually look at this child sex doll?
I did.
And can you please describe it for the court?
It's made of some type of silicone. It is anatomically correct. It closely resembles a prepubescent child. The breasts are underdeveloped but present. The vagina is disturbingly accurate portrayal of a real child's vagina. It has a vaginal orifice, an anal orifice, and a oral orifice. It also in the box was a phallic-shaped UV light with a plug that seemed to be used for the purpose of cleaning, to insert into these orifices to sterilize them. And the doll was found. The doll has some type of skeletal system. It can actually be posed, and it will maintain that pose. And as well as having a removable, detachable head with very lifelike eyes, eyelashes, and it's very realistic.
Was this a life-size doll?
Yes, it is life-size of a prepubescent child.
Can you estimate the age or say anything about that at all?
It appears to be a child, representing a child 5 to 10 years old.
Okay. And so it would also represent the height and weight of a child that was that age?
Yes, when I picked it up and carried it, I was surprised at its weight. It weighs as much as an actual child of that age.
And you already mentioned that it was made out of some sort of silicone material.
It's a flesh-like material.
It was a flesh-like material?
Yes, it has similar properties to, like a ballistic gelatin is designed to act the way a human body would when shot. This appears to have been designed to act the way a human body would when touching it.
Okay, and at some point was the victim, the actual victim in this case, the then 5-year-old, now 6-year-old daughter of Ashley, who we already discussed, sent to the child protection team to be interviewed?
Yes, they went to the child protection team. She underwent a forensic interview on December 22nd.
And were you present for that interview?
I was.
And do you always watch as the lead detective from a different room when those interviews are being conducted?
That is correct.
What did the victim disclose in that interview?
She disclosed that while she was in the living room, the defendant told her once to pull her pants down, asked her to wipe her buttocks on his face. She told the case coordinator who was interviewing her that she complied and did so, and also wiped her breasts on his face. And that while she did this, he laid on the couch in the living room with his hands above his head in a relaxing pose. Once having done this, she got dressed and went back to her room and continued playing.
And so her butt, without any clothing or underwear, actually made contact with the defendant's face at his request.
That is correct.
And you indicated that there was actual contact between her breasts and the defendant's face as well.
Correct.
At some point, did you interview Ashley, the victim's mother?
I did.
And what did she tell you?
She explained that her cousin Donald had needed a place to stay, so she allowed him to sleep on her couch for a few weeks, and he kept his belongings in the living room area of her residence. And sometime in October of 2020, he stole a vehicle belonging to Ashley's father and ended up crashing at Seminole County and was arrested for possession of a stolen vehicle by, I believe, the Florida Highway Patrol. While he was in jail, she began to gather his belongings to remove him from her residence. When she located the doll, Ashley called Donald's sister, Lise Kaiser, concerning the doll. The sister, her immediate response was, "It probably looks like a little kid."
Does that mean that the defendant's sister, as well as his cousin, had concerns about his behavior prior to these allegations being made?
Yes.
And what concerns exactly, if you can elaborate on that?
So I spoke to the sister, Elise Kaiser.
I would object to relevancy of these questions regarding the actual PBL that's charged here.
Counsel, restate your question for me, please.
Your Honor, I asked if the victim's mother, as well as the defendant's sister, had concerns about the defendant's behavior, which what is about to be testified to is concerns regarding him having interest in children, including possession of child porn, and that he had struggled with that in the past. That there is case law on that exact point, that is admissible when we're talking about proving lewd or lascivious molestation, because the state has to prove that the touching was done with a specific intent. I would be happy to try and pull that case law up, but of course, we are at an Arthur hearing today.
Right, all right, I'll overrule it at this time. You may proceed.
You can answer the question, what concerns were brought up?
When I spoke to 34-year-old Elise Kaiser, the defendant's sister, she told me that approximately 2 years prior, that Donald had overdosed on heroin. During the time following that, he began saying what she described as odd things and indicated that he was attracted to children. He confided in Elise that he was upset because he had viewed child pornography. He said that he needed help. As a result of this, Elise told me that she, in the future, after that, she kept her own children away from him and did not allow him to be around them. And she had been aware of the sex doll in the past. Donald had discussed it and had talked about it, but he never mentioned that it was childlike in its appearance. But apparently it was something that had been discussed in the family. They were aware that he had it.
Okay, and
Sorry to
then.
interrupt. Detective, are you reading the affidavit for the warrant or something else?
I am reading something else.
Okay. I'd ask that the witness not read. I don't know what he's referring to, and it appears that he's been reading.
Wait, I couldn't hear you. You asked that he not read?
Right. I'm not sure what he's looking at. All I have is the affidavit for the arrest warrant, so if there's something additional.
That's all I have as well.
The case file has not been prepared yet. The warrant was just issued last week. I'm reading from my report that will be provided to the state and thus, and ultimately the discovery.
And Detective, if you could just not read from.
I don't think he can read from the report, Counselor.
This has to be from your own memory. If you need to look at something, we can certainly ask a follow-up question as to that. So to clarify, you have talked to the victim's mother as well as the defendant's sister?
Correct.
Okay. And Your Honor, we would like to show some photographs that have been collected or taken of the sex doll. If Your Honor needs to see those at this point, those have already been shown to the defense.
Give me one moment. You've seen them, Counselor?
I have.
Do you have any objection to the photos?
No, I have no objection to the court looking at them for this hearing.
All right.
And all we have is the computer because the detective and I drove here to attend the hearing. Is that acceptable to the court?
Is there any objection from the defense?
No objection as long as it's the same photos that I saw.
All right, as long as it's the same photos she saw. Yes.
I don't believe I have any other questions for the witness at this time.
Thank you, Counselor. Any cross-examination for this witness?
Yes, Your Honor.
I'm just going to ask you to get really close to the microphone. Sorry, same thing as, it's just the masks, it makes it really hard to hear.
Now, you testified that Miss Gibney first found the sex doll and then asked her daughter some questions?
I believe that was the order of events.
Okay. Do you know the language that she used or how she broached the topic with her daughter?
No, I couldn't tell you word for word what she said, no.
Okay. And Miss Gibney gave a couple different statements, right? She was interviewed first by Deputy Mooney.
Yes.
And at that time, she said that the victim told her to remove her clothes and shake her butt in his face.
I'm sorry, the victim told her?
The victim told Miss Gibney that Mr. Garrell had, sorry. The victim disclosed to Miss Gibney that Donald had told her to remove her clothes and shake her butt in his face.
Are you reading from your warrant affidavit or from the initial report?
All I have is the warrant affidavit.
Okay. I believe that was that was the order of events. That's what I wrote in the affidavit, so it's been a while since I've reviewed it, but yes, I'm going to go with that.
Okay. And then she was interviewed the next day. I'm sorry, you were assigned the next day, and she was interviewed by you at CPT on December 22nd.
Not by me, no, by a case coordinator.
Okay. Were you watching the interview?
Yes.
And it was recorded?
Yes.
Did you watch it afterwards or just live?
Live.
Okay. And at that point, she said that her daughter disclosed to her that Donald had told her to remove her clothing and shake her buttocks in her face.
Yes.
Okay. And then on that same date, after that interview, CPT interviewed the victim, Miss Gibney's daughter.
Yes.
Okay. And did you watch that, or were you involved in some way?
Yes. No. Oh, okay. Hold on. I think I'm confused. What we were just talking about the interview with the mother, Ashley.
Right.
That interview I conducted.
Okay.
I watched the interview with Evie, the child.
Got it. So the mother told you that her daughter told her that Donald had asked her to take off her clothes and shake her buttock in his face.
Yes.
Okay. And then after that, the child was interviewed by CPT.
Correct.
Okay. And that's when the child told CPT that she was told, she used the term wipe
Yes.
her buttocks in his face.
Yes.
And she didn't use the word shake.
I don't remember. I believe she did.
Okay, your report just mentions wipe. The victim told Jacqueline that Donald had once told her to pull her pants down and asked her to wipe her buttocks on his face. Is that correct?
Yes.
Okay. And then you also added that she said that she also wiped her breasts on his face as well.
Yes.
But that is not clear that it was at his direction. That's something that she said that she did.
I would have to review the interview and see exactly how it was worded.
Okay. But your report doesn't include anything about him asking her to wipe her breasts on his face.
In the affidavit?
Correct.
May not.
Okay. And you're familiar with CPT, right?
Yes.
They're specially trained to interview children.
Correct.
They have special ways to do that to avoid any leading or suggesting any type of answer.
Correct.
Okay. Now, this child's mother didn't have that kind of training, right?
No, of course not.
And so you're not sure how the questions were posed.
No.
And that was the first person that this child said anything like this to.
Yes.
Okay. I have no further questions. Thank you.
All right, thank you, Counselor State.
And so today you are testifying based upon your own involvement and own recollection of the individuals who you spoke to, as well as you witnessing the victim make disclosures at the child protection team.
That is correct.
Okay, I don't have any other questions.
All right, any other witnesses?
No other witnesses.
All right, does the defense have any witnesses to call?
No, Your Honor, just argument.
All right. You may proceed.
Would you like me to go first, Judge?
Yes.
Sorry. Your Honor, there has now been additional testimony that's been presented to Your Honor besides just what is in the arrest affidavit. The lead detective has testified about conversations and interviews that he himself conducted, as well as the victim's child protection team interview that I myself have not seen yet, but we could present it to Your Honor if you choose to need to hear that at this point. I know that we are at the initial appearance hearing, but because testimony's been provided and evidence has also been admitted to the court, I wanted to make that suggestion that there is additional evidence that exists in this case. The victim, of course, was 5 at the time the sexual allegations took place. She is now 6. However, she very carefully disclosed, as it's been testified to, and how it is worded in the report, that her uncle had asked her to remove her clothing in the living room. She complied with that request, and specifically, it's been shown that she removed her pants and underwear, at which point the defendant asked her to, in a variation of ways, either shake her butt or move her butt, and then eventually move it towards his face, at which point actual contact was made between by the victim's butt and the defendant's face. That right there, because of her age, is a lewd or lascivious molestation. There's an additional lewd or lascivious molestation of the allegation that was made by the victim that was then disclosed in the CPT interview, that she had also rubbed her breasts on the defendant's face. So right now, we actually have enough evidence for more than one lewd or lascivious molestation. There's actually 2. And because of her age, because she was under the age of 12, this is the 25-year minimum mandatory life felony of lewd or lascivious molestation of a child under the age of 12. The evidence regarding the sex doll, Your Honor, absolutely comes into play. The sex doll, you obviously saw photographs of it. It is very realistic. In fact, it is made out of a material that could mimic skin of a real individual. It looks like a child. This detective, who of course has experience in this field, estimates that the doll looked from anywhere from 5 to 10 years old. It also weighed the same that a child of that age would weigh. It also had the same height as a child of that age would have. It has multiple orifices, which Your Honor saw, which are extremely realistic. It also has a cleaning feature that is basically, my understanding is it's a USB plug-in to clean all of the orifices. You insert something and it does clean those orifices. I ask that Your Honor take that into consideration based upon my prior argument that possession of, in this case, a childlike sex doll, or what the case law that I'm familiar with is possession of child porn, that is admissible as evidence of the defendant's lewd intent. So that comes into play, and that's why the state spent time on that today, because that is admissible with regard to proving lewd or lascivious molestation of a child under 12. I would also like to point out that this victim is in the same exact age range as this very real sex doll that was uncovered. Would also like to point out the fact that that sex doll, which was still in the box with the shipping label, had the defendant's own name, full name and address. It had been shipped to him. The detective investigated and found that it came from a certain website from China. So I think that's important to note. And then finally, we have admissions that have been made by the defendant regarding his desires towards children that were made not only to the victim's mother, but also to his own sister. So we're not just taking one individual's word for it. There have been two females, one of which is his own sister, who has testified that the defendant has struggled with this in the past, and he's admitted to possessing and looking at child porn and having these desires towards young children. And again, that's the same argument that I made about the sex doll and possession of child porn. That is admissible to show that there was a lewd intent. So that evidence supports, and those are his own admissions, those support the lewd or lascivious molestation charge. And for all of those reasons, as well as what has already been provided in the arrest affidavit, in the photographs, as well as in the testimony, we ask that you keep the defendant at no bond.
Thank you, Counselor. Defense, you may proceed.
Thank you, Your Honor. First, I do have one case. Unfortunately, I don't have access to a printer, and I didn't get the affidavit until I arrived in court. I can email it if the court would like, or I can read out the citation if you have access.
You can email it. I didn't bring my computer in here. I can just go back to my chambers and print it.
Your Honor, I can print it.
Oh. Or the state can print it. If you email it to her, do you want to give her your email address?
tmay@sa09.
.org, right?
Yes.
Okay, it was just sent from Westlaw, so I'm not sure if it's come through.
Nelsie.
Right. Luckily, it's a fairly short case.
Yes, thank you, Counselor. Have a nice day.
May I approach?
Yes, thank you. Thank you so much. All right, Counselor, you may proceed.
Yes, Your Honor. First, I just want to point out that the majority of the testimony and the state's argument concerns the sex doll, which is a misdemeanor. I understand the state's argument about why that's relevant. I'm not familiar with which case she's referring to, but the vast majority of the testimony and argument had to do with the misdemeanor charge. I'd also like to argue that the photos that I saw, it's unclear how childlike it was. This detective is not an expert in child physiology, and the court should not accept his opinion based on that. It does seem to be some kind of schoolgirl type of situation that is a common theme, I think, in regular pornography, adult pornography. And so it's unclear from here in these photos how strong that evidence is. But more importantly was the change in testimony of the child in this case concerning what actually was was said to her and what she actually did. So first we have the interview with the mother saying that she found this sex doll, was very concerned. She was so concerned that she put it in her car. She didn't want it in her house. One can imagine how emotional she may have been finding this, and then the emotion with which she spoke to her daughter. We don't have a lot of information to go on about how this topic was broached with her daughter, but there is the concern that the way it was done and the terms used and the questions asked could have implanted this idea, could have tainted all the other interviews that were done with the child. And so that is a big concern in this case regarding proof evident presumption great. First, the mother said to a different deputy that her daughter told her that she was told to shake her butt in his face. And that stayed consistent a month later when she gave her interview to CPT, or I'm sorry, to the detective at CPT, where she said that he told her to shake her buttocks in his face. Then the child was interviewed, and she did not say shake. She now says wipe her buttocks on his face, and she now introduces for the first time that she also wiped her breasts on his face. Again, it's unclear that the wiping or the shaking, what type of terminology was used. But the change in testimony, I think, is significant. Additionally, the addition of the breasts, again, we don't know how that was asked. But she first said, and if you look at the affidavit, she was on page 2. The victim said she had never been touched inappropriately on her dots, which she indicated were her breasts. And then in the next paragraph, she said that Donald had once told her to pull her pants down and asked her to wipe his buttocks on her face. She said that she complied and did so and wiped her breasts on his face as well. So again, it's unclear. It doesn't appear that that was done, that was enticed by the defendant or something that she did on her own. Finally, the case that I provided to the court has to do with a case where the defendant had grabbed or wiped or touched the buttocks of 2 girls. If you would look at where head notes 2, 3, and 4 are located, it says that each contact was brief. I'm sorry, the court found that this was not lewd or lascivious without any additional sexual words or acts. It specifically says that each contact was brief, unaccompanied by suggestive remarks or body language. As this court observed in Eagle, a lewd or lascivious purpose imports more than a negligent disregard of the decent proprieties and consideration due to others. The evidence is simply insufficient for a finding that MLC's conduct was grossly indecent, lustful, licentious, or unchaste. We therefore hold as a matter of law that the state did not prove that MLC committed the delinquent acts as alleged in count 1 and 4 of the petition. Similarly, in this case, the evidence is that if it's to believe at all, that it was brief, that there were no words or actions of a sexual nature to accompany this. The child told CPT that Mr. Garrell was lying on his back with his hands behind his head. Doesn't sound like he was using his hands to do anything, saying anything sexual, or doing anything else that could be considered enough to make these facts into a lewd and lascivious molestation. Additionally, I would argue that count 1, I believe, is an F2, and so he's entitled to bond on that count and the misdemeanor. Additionally, even if the court does find proof evident presumption great, which we do not believe exists here, the court can use this discretion to grant a bond in this case. We would ask the court to grant bond either way. As Mr. Garrell has a good job, he works installing solar panels. I've spoken with his family that's indicated that his boss is going to keep him employed pending this case. I have an address in New Smyrna Beach. He will have no contact with any of the witnesses, and the court can order him not to have contact with any other minors. And so Mr. Garrell is not a danger to the community at this time and should be granted bond. He believes that when speaking with him and his family, they believed that they could afford a bond of $5,000. The clerk system had indicated that this was a lower charge. So that conversation was before court when I received the affidavit. But we would ask the court to consider a bond at or near that amount in this case. Thank you.
All right, thank you, Counselor. And I have the case in front of me now at 875 Southern 2nd, 810. It's MLC versus the State of Florida. I see that it has negative treatment. So this is a second DCA case, and there's a note that says that it's a key site. There's negative treatment by the 5th DCA, which is our DCA. Do you have that case, or do you know what the negative treatment was?
Yes.
Can the state print that one?
I'm looking into it, Your Honor.
Okay. Thank you, both.
So I think this case is similar in that, if I remember correctly, this was a situation where it was simply a jury question, whereas the MLC case mentions as a matter of law, and this had to do with the judgment of acquittal. So it doesn't say that that's not the correct law, but it said that a JOA should not be granted and that it's a jury question. Obviously, in this bond hearing, the court serves as fact finder like a jury would in the trial, and so I don't think that this case takes away from any of our argument.
All right, thank you. I just needed to make sure of that because the 5th is, of course, our DCA.
Mm-hmm.
Does the state have any response to the defense argument or case? Did you have a chance to review this case law?
I did, and Your Honor, I would make the argument that it cannot even be compared to the set of facts that we have. In our case, we have a 5-year-old child that was asked by a grown man to take off her clothes, including her pants and underwear, and shake her butt and back her butt up, her bare butt, onto his face. He was sitting back on a couch, relaxing with his hands behind his back. So essentially, the state would submit to the court that he had asked a 5-year-old to dance in front of him and sit on his actual face with her butt. So the facts of the case that's been cited in MLC are drastically different. It involved, my understanding is if I'm not mistaken, a school teacher who made the argument that the touching was accidental, and there was even discussion about a brush over and that it was brief. So I would just heavily argue to Your Honor that that case should really be given little to zero weight.
All right, thank you. I don't need to see the 5th DCA case, Counselor. I'm going to take your word for that. But at this time, this court finds that the proof is evident and the presumption is great that your client committed a lewd or lascivious molestation. The victim in this case, even at a young age, made at least 2 statements to 2 separate people on 2 separate occasions that your client, it started with requested that she shake her buttocks in his face, and then she said that he requested that she wipe her buttocks on his face. And counsel, by your own statement, the CPT is trained to ask questions in a way that don't suggest an answer or lead the child. And it's in that interview that the child discloses even more disturbing facts, that your client asked her to wipe her buttocks on his face, which is a lewd and lascivious molestation. That touching is the molestation. I do find the evidence presented here today about the doll that does resemble a child is relevant toward lewd and lascivious intent. I would distinguish this case from the facts in MLC versus State of Florida at least two significant ways. One, MLC was not quite 13 years old when he allegedly committed several acts of lewd or lascivious molestation on two of his middle school classmates. So the defendant himself was not quite 13 years old, so he was 12 when these acts were committed. Your client is a grown man. Also, in MLC versus State of Florida, Section 1, the court says, lewd or lascivious molestation, as provided in Section 800.045 sub A, sub C, sub 1, Florida statutes, prescribes the offender's intentional touch of the victim's buttocks or clothing covering them, quote, in a lewd or lascivious manner. Here, however, there is no evidence of lewd or lascivious intent in MLC's split-second contact with the girl's buttocks. So, split-second contact is very different from the facts that are alleged here in this affidavit and the warrant. So I find that this case is distinguished based on those facts. I understand your argument that even if the court finds proof evident and presumption great, I can grant your client a bond, but I'm not inclined to do that at this time. All right, having found proof evident and presumption great, at this time I will hold you, Mr. Garrell, at no bond on count 2. What level felony is count 1?
I believe it's an F2.
It is an F2, Judge.
I want to be sure, okay. Your bond on count 1 will be $25,000. Your bond on count 5 will be $10,000. You're not allowed to have any contact with the victim or the victim's family. You understand that? I can't hear you.
Yes, ma'am.
You're not allowed to have any contact with any minor child under the age of 18. Do you understand that?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
And at this time, as to 20 CF 13321, I'm revoking your bond.
Your Honor, if we may be heard on that issue.
Yes.
That case predates this one, and so there is no violation of his bond conditions. We would ask that no action be taken on that case.
And the
Thank you.
state agrees.
Thank you, Counselor. I'll take no action on that case. Is there anything further from either party?
Not from the state.
No, Your Honor.
All right, thank you. Court is adjourned for the day.
Thank you.